Do you remember what happened May 17th, 1954?
I'm afraid I do not, Miguel.
Well, let me tell you about what
John
happened.
Brown versus Board of Education. Linda Brown argued that the operation of segregated schools was harmful to African American children. Her defense contended that legal segregation resulted in both fundamentally unequal education and low self-esteem among minority students. The Brown family lawyers argued that segregation by law implied that African Americans were inherently inferior to whites. For these reasons, they asked the court to strike down segregation under the law, which tells us that it was clearly a civil rights case. On the other hand, the Board of Education argued that separate schools for non-whites in Topeka were equal in every way and were in complete conformity with the Plessy standard. Buildings, the courses of study offered, and the quality of teachers were completely comparable. In fact, because some federal funds for Native Americans only applied at the non-white schools, some programs for minority children were actually better than those offered at white schools. Furthermore, they argued discrimination by race did not harm children, which was obviously not true. The segregation of white and African American children in public schools of Topeka solely on the basis of race denied the African American children equal protection under the law guaranteed by the 14th Amendment. The Board of Education is a landmark case because it held that segregated schools were unconstitutional, therefore overturning the separate but equal doctrine set by Plessy versus Ferguson in 1896.
Segregated schools violate the Equal Protection Clause of the 14th Amendment.
On June 12, 1995, Adirond argued against Federico Pena that race-based presumptions in federal subcontractor programs violate equal protection under the law, to which Federico Pena answered that minority-owned businesses were socially and economically disadvantaged, therefore need an advantage. On Adirond versus Pena, it was a civil rights issue. The case was a landmark case because, although the decision did not prohibit the federal government from involving itself in affirmative action programs, it marked a retreat from the U.S. Supreme Court's earlier endorsement of minority set-aside programs as a remedy for past racial discrimination.
So the ruling was that it declared that classifications based explicitly on race must be narrowly tailored. The court furthered compelling government interests by overturning the lower court's ruled against Adirond by a vote of 4 to 5. Court case of Shelby County versus Holder. Shelby County, Alabama, and Eric Holder, Junior Attorney General, were the two in the case. Shelby County filed a suit believing it was unconstitutional to permit injunction versus Alabama enforcement. The case had to do with voting rights and took place on June 25th, 2013. The county argued current conditions no longer justify preclearance and that the coverage formula is outdated. They argued that the preclearance regime exceeds Congress's power to enforce the 14th Amendment, and that violates the 10th Amendment. Holder, however, argued that all voting rights are outdated from the Voting Rights Act. This is a landmark case because it requires states and local governments to obtain federal county preclearance before implementing changes to laws and practices. The court ruled that it is unconstitutional because the Shelby County is attempting to use 40-year-old facts from the Voting Rights Act. In the case of Gritter versus Bollinger, Robert Gritter and Lee Bollinger, president of Michigan, were the two involved in the case. Gritter accused the University of Michigan of discriminating against her because of her race, and that they violated the Civil Rights Act. The case contained civil rights and took place on June 23, 2003. Robert Gritter argued that Michigan did not admit her because of her race, and took other students over her not because of their academic achievements but because of their race. Michigan, however, denied any such use of this. Landmark case because the court upheld policies such as affirmative action, which allowed minority students to be favored over white students. The final ruling that the Supreme Court gave was that the school, Michigan, was not in violation of the Civil Rights Act.
So this case is about Regents of the University of California versus Becky. Well, those that were involved were Davis Medical School at the University of California and Allen Becky. And what happened was that the University of California Special Admission Program for minorities led to Becky's denied admission as he is a white male. Becky claimed that the school's decision violated his civil rights. It took place in Washington, D.C. on June 28, 1978, and it is considered a civil rights case. The school argued that it was a method to make up for past discrimination against minority groups, and it gave an opportunity to those that have been denied of getting an opportunity to be admitted. Becky's argument was that it conflicted with Title VI, in which was part of the Civil Rights Act of 1964. Furthermore, it violated the Equal Protection Clause of the 14th Amendment, which basically states equal protection of the laws. Also, the special admission program can be considered reverse discrimination, as it decreased opportunity to a group of who do not get discriminated, in this case, white males. The court ruled that race could be one factor among several considered for admission, but it cannot be the only factor considered. Since race could be considered, the ruling was the first court approval of affirmative action.
Supreme Court ruled in favor of Becky by finding the school's special admissions program unconstitutional because of its use of quotas, and ruled that Becky should be admitted.
Heart of Atlanta Motel versus United States. So those that were involved were part of Atlanta Motel Incorporation and the United States. Well, Rolston claimed that a provision of the Civil Rights Act of 1964 required motel and motel owners to provide service to African Americans. This provision could not be enforced against privately owned accommodations. This case took place in Washington, D.C. on December 14, 1964, and it is considered a civil rights case. So the arguments were that Rolston, the motel's owner, stated that Congress exceeded its power when it passed Title II of the Commerce Clause. He also felt that the act violated the Fifth Amendment, which is no person shall be deprived of life, liberty, or property without due process. The United States hits back that the denial of granting accommodations to African Americans is interfering with interstate commerce. Also, the Fifth Amendment allowed reasonable regulation, so the act did not violate their liberty or due process. This case is very important because the Civil Rights Act of 1964 had its first major test as the court's decision of African Americans in their civil rights struggle. Furthermore, the Commerce Clause was a powerful tool in ending racial discrimination.
The Supreme Court ruled in favor of the United States by upholding Title II of the Civil Rights Act of 1964.
Nice, dude.